what are the origins of the idea that it's very important to listen to the voice of the child within family cases? The concept of the right of the child to be heard within the family justice system derives in part from the Convention on the Rights of the Child, which was adopted by the United Nations back in 1989 and ratified here in the United Kingdom 2 years later. Article 12 of that convention provides this, that states parties should assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the view of the child being given due weight in accordance with the age and maturity of the child. It goes on to provide, for this purpose, the child shall, in particular, be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or an appropriate body in a manner consistent with the procedural rules and national law. Of course, this convention has not been incorporated directly into English law, and Article 12 is merely directive to states to secure to children the rights to express views and to be heard in judicial proceedings. But in compliance with those obligations, Section 1, subsection 3 of the Children Act 1989, with which many of you will be very, very familiar, provides that in private and public law applications, the court shall, among other considerations listed in that section, referred to, of course, as the welfare checklist, have regard to the ascertainable wishes and feelings of the child concerned, considered in the light of his age and understanding. I should also briefly mention the European Convention of Human Rights, incorporated into English law, which also adds to the rights of the child to be heard and to participate in decisions made in his or her life, since a child is, of course, entitled to the protection of, in particular, Article 6, the right to a fair trial, and Article 8, the right to family life, as much as any adult. Jack in Frankfurt, Germany. The question is, in Re W, it appears that at first instance, the CAFCAS officer made an error and that the CAFCAS officer's view was preferred to the views of the children in the case. What is the scope of the role of the CAFCAS officer? Merely to channel information or to offer a conclusion? I think in essence it's to not only, as we've discussed, channel the views and wishes and feelings of the children, but more particularly to offer a professional analysis of what would be in the best interests of the children. In Re W, the question was whether the mother should have leave to remove the children permanently from the jurisdiction, and a particular authority called Pain and Pain sets out the criteria which the court has to look at in balancing what is the right decision for the children. And part of the CAFCAS officer's function is to address those particular questions along with what we term the welfare checklist, which applies in all questions relating to private law children's litigation. So to answer your question, in nearly all cases, the officer's role is not only to channel the children's wishes and feelings, but also to offer a conclusion. I should say that in this case, while you're right in saying the Court of Appeal said that the CAFCAS officer and therefore the judge were wrong in the conclusion they reached, that was in part because the crucial information about the father's finances, which played such a crucial role in the decision, the information was wrong at the beginning given to both of them, largely because the ancillary relief proceedings had been heard at the wrong time. I'm asked by Jane Rees in Dorset, could you attempt to outline the reasoning behind the choice of age 7 or age 9 being the age at which the child should be given the opportunity to be fully involved in proceedings. I'm not sure I can outline the reasoning. Obviously, there is a body of research looking at the sort of ages at which children are likely, and one has to make generalizations because, of course, children's individual maturity and intelligence varies at any age, but there is some degree of consensus at the sort of age where children are likely to be able to maturely comprehend some of the issues which involve them. But it has to be said, as the President indicated in his address, that really one is taking a rule of thumb and, in a sense, plucking a particular age based on experience. Of course, nobody is saying that all children of that particular age should be involved in a particular way or at all, but really setting a benchmark at which very much more active consideration should be given as to whether this particular child, first of all, has sufficient age, understanding and maturity to be more fully involved, and if so, how.